Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly.
Now live.
Okay, so good morning everybody and welcome to the 93rd meeting of the Autonomy Committee. Some members will be attending this morning's meeting via Starleaf and our witnesses will be briefing via Starleaf. The committee will be broadcast live when open to the public and a recording will be made available on the committee's webpage on the Assembly website. Just to remind members that bill briefings will be hand-sorted where appropriate as per protocol and to ask members to mute their tablet devices. So moving on to item number 1, which is apologies. I think we have just had apologies through from Mike. Is that right,
Yes,
Peter?
Yes, Chair, just Mike so far.
Okay. And I think some other members might have to come in and out just over the course of the meeting for debate. So yes, we will struggle on as best as possible. Okay, so item number 2 then is Chair's business. 2.1 at page 5 of our packs is an invitation from Retail NI to the Future High Street Summit. It takes place on the 30th of March and registration details are in the pack. So that's for members to note. And then moving on to item number 3, which is our draft minutes. There is a copy of the minutes from the meeting held on the 2nd of March at page 7. So are members content that those are an accurate reflection of the meeting?
Chair, can I just highlight, we have put in a note, and we'll do it again this week, that some members couldn't attend, and I had to offer apologies last week because they had to be in the chamber. That'll now be adopted across all committees.
Okay.
So if members just let us know if that's going to be the case for them, and we can make sure it's highlighted.
Okay, thank you. So moving on then to item number 4, which is the Employment 0 Hours Workers and Banded Weekly Working Hours Bill briefing from RAISE. There is a RAISE briefing paper at page 14, a response from the department regarding the bill at page 55, the Hansard from the briefing with the Women's Policy Group on the 23rd of February at page 63. So can I welcome to the meeting Orla Drummond, who's Research Officer in RAISE, and Michael Scholes, who's also a Research Officer in RAISE. And I'll hand over to yourselves to make an opening statement, and then we can bring members in for any questions. Oh, we can't hear Michael.
Apologies for that. Thank you very much. I take it you can hear me and see me now, okay? Yeah?
Yes, Michael, yeah.
Great. So I'm going to summarise the key points of the paper and then hand over to Orla, who's going to discuss the equality implications of the bill. So the paper really aims to support the committee and the wider assembly in the scrutiny of the Employment 0 Hours Workers and Banded Weekly Working Hours Bill. Throughout the paper, as we usually do in RAISE, we have presented issues and questions in blue boxes for the committee's use. We're starting on section 1 on page 21 of your packs. It provides a statistical profile of 0 hours workers in the UK and in Northern Ireland. Official statistics on 0 hours contracts are published quarterly by the Office of National Statistics using data from the Labour Force Survey. Historically, the prevalence of 0 hours contracts has been consistently lower in Northern Ireland than other parts of the UK. The most recent figures show that only 1.2% of working individuals in Northern Ireland are employed in 0 hours contracts. The latest UK average figure for the same period is at 3.2%. And overall, there's not been a significant rise in the reporting of 0 hours contracts in the UK since 2014. Section 2 then on page 23 of the pack provides background information and gives an overview of the bill as introduced. Back in 2014, the Department for the Employment and Learning conducted a consultation on 0 hours contracts. And the consultation report did not call for an outright ban. In 2016, Section 18 of the Northern Ireland Employment Act gave a power to bring forward regulations that could prevent abuses associated with the use of 0 hours contracts. And then in January 2020, the New Decade New Approach Agreement stated that the executive should move to ban 0 hours contracts. And finally, in November 2020, Bill sponsor Gemma Dolan introduced her bill into the Assembly. Now, the bill does not place a ban on 0 hours contracts. Instead, it seeks to limit their use by introducing a system of banded hours contracts. So I'm going to briefly give a overview of the main points of the bill. So the bill contains definitions for 0 hours workers and 0 hours contracts. It entitles workers to claim 3 hours pay if they are called into work and are not given any work. It outlaws exclusivity clauses, and I'll discuss this later on in section 4. It gives the Labour Relations Agency a role in conciliating disputes. It sets out the right of a worker to be placed in a band of weekly working hours that reflect the actual hours completed over the previous 3 months. And it also gives the Department for the Economy the power to make regulations concerning the paperwork that employers must keep in relation to the banded hours system. So section 3 then discusses these provisions in more detail. That's on page 29 of your pack. So basically there are 3 elements to this section. There's the definitions, the banded hours system, and the ban on exclusivity clauses. Clause 1 of the bill, as introduced, presents statutory definitions for a 0 hours worker and a 0 hours contract. However, there are many different types of 0 hours arrangements, and reaching a consensus when defining 0 hours contracts is difficult. So the committee may want to reflect on the definition that's contained in the bill, whether or not it's too broad or too narrow. Clause 8 of the bill provides for a worker to be placed on the 8 banded weekly hours contracts. If the worker's hours are set out in their 0 hours contract does not reflect the actual hours that they are working every week, they can request to be put on a band that does reflect the hours that they typically work. The bill produces an obligation on employers every 3 months to monitor weekly hours worked by individuals and to duly inform them in writing whether they are entitled to be placed in a band. The band is calculated by reference to the weekly average working hours over the previous 3 months. Now, critics of the banded hours system suggest that it doesn't give employers or workers the flexibility that they need. And also there's been concerns raised but that the system is not fit for purpose in some employment sectors such as tourism and hospitality due to the seasonal nature of some of this type of work. So the next key provision relates to the exclusivity clauses. Now this is a practice where some individuals on 0 hours contracts are prevented from working for another employer even when their primary employer does not have any work for them. Clause 3 of the bill states that the employer cannot demand that the worker does not do any work outside the 0 hour contract. This effectively bans the exclusivity clauses. However, clause 14 of the bill states that if a 0 hours worker is placed on a band, they are no longer defined as a 0 hours worker. This may lead to a situation whereby a worker who was previously protected from exclusivity by a 0 hours contract is now not protected and vulnerable to exclusivity clauses being placed on them by unscrupulous employers. However, representatives of the hospitality and retail sectors have cast doubt on the prevalence of exclusivity clauses and expressed an opinion that this is a non-issue in Northern Ireland. So moving on then to section 4 on page 38 of your pack, and this presents a comparative perspective from other jurisdictions. In GB, the 2015 Small Business, Enterprise and Employment Act contains provisions banning exclusivity clauses in 0 hours contracts. In 2016, the UK government published Good Work, the Taylor Review of Modern Working Practices, which was generally positive about the flexibility provided by 0 hours contracts. However, it also stated that the flexibility was largely one-sided in favour of the employer. In the Republic, the Department of Jobs, Enterprise and Innovation commissioned the University of Limerick in 2015 to undertake research into the prevalence of 0 hours contracts in Ireland. And that report recommended that banded hours could provide more certainty for those on 0 hours contracts, particularly in the retail and hospitality sectors. And in 2018, the Employment Miscellaneous Provisions Act introduced a system of banded hours in the Republic. Section 5 then looks at other issues for consideration, and Orla, as I said at the start, will cover the equality and human rights aspects shortly. Now, I've provided a discussion of the general pros and cons of 0 hours contracts on page 49. The key merits include the flexibility, the ability to retain experienced staff, and the cost. Now, the demerits or cons include the uncertainty of regular income, a lack of fairness in terms of the employment rights and entitlements, and the potential for exclusivity clauses being put in place by unscrupulous employers. So finally, the paper gives an overview of the potential costs to the public purse. Clauses 7 and 16 of the bill make provision for the Labour Relations Agency to monitor the compliance of employers and place a key role on the resolution of any disputes with regard to 0 hours and banded hours contracts. The Labour Relations Agency has indicated that a staff complement of 1 deputy principal, 3 staff officers and a small administration team may be needed to perform the new duties specified under clauses 7 and 16. And based on costings from the average salaries for 2021, the total cost of a new team dedicated solely to undertake these new duties arising from the provisions created in the bill equates to around £267,000 per year. However, it should be noted that that figure is purely illustrative, based on assumptions made without any detailed costings or impact assessments being done. So thank you, Chair. I'm now going to hand over to Orla for her consideration of the human rights and equality impacts of the bill.
Thank you, Michael. Good morning, everyone. I would like to briefly cover Section 5 of the bill paper, which includes any human rights and equality consideration, and that's on page 44 of your pack, regarding the potential human rights and equality impact of the bill introduced in the Assembly, key areas for consideration concern the negative impacts for employees and workers and the disproportionate bearing that has on women, younger workers and ethnic minorities. There's been an increased scrutiny of 0 hour contracts in recent years. While they are often lauded for their flexibility, there are a number of documented detrimental impacts for workers. According to Unison, 0 hour contracts present huge drawbacks in comparison to permanent and regular work. For example, the need to respond to calls to attend work frequently at short notice disrupts life outside of work and places a strain on families, especially those arranging care for dependents. The variability of earnings throws into doubt an individual's eligibility to claim various state benefits. For example, the work and tax credit for a single parent can only be claimed if that person works 16 hours a week. But whether someone exceeds these hours can vary from week to week under 0 hours, creating even greater uncertainty over income. In addition, lack of income makes it extremely difficult to obtain a mortgage or other form of loan. A summary of Unison's concerns are detailed in pages 44 to 45 in your pack. In relation to obligations under Section 75 of the Northern Ireland Act 1998, there are a number of areas for consideration. The first of these is gender. According to NICFL, women are around 2/3 more likely than men to be a 0 hour worker. The Trade Union Council have highlighted that the lack of a work guarantee and related unpredictability of work from week to week and day to day can put a strain on families, making it very difficult to arrange childcare or elder care. Due to 0 hour contracts, uncertain employment status and the intermittent nature of their employment, many parents also lose out on family-friendly rights, including the right to request to work flexibly and the right to return to their substantive job after maternity or paternity leave. This point was emphasised by the Equality Commission in its formal investigation into the treatment of pregnant workers and mothers in Northern Ireland workplaces. Respondents working on non-permanent contracts were more vulnerable to job loss during pregnancy, maternity leave or on return to work. They found that 1 in 5 respondents who were employed on fixed-term, temporary, 0 hour contracts or other casual contracts lost their job. In relation to gender and race, A recent joint report from the TUC and the equality organisation, Race on the Agenda, highlights that those from Black and minority ethnic backgrounds are almost twice as likely to be on zero-hour contracts as white men, and almost 1.5 times more likely than white women. The report, published in 2021, warned that far from providing flexibility, zero-hour contracts were trapping women from BAME backgrounds into low pay and insecure work. That resulted in those workers struggling to manage their household finances as well as plan their lives. The joint report describes zero-hour contracts as the most egregious example of one-sided flexibility at work, handing the employer total control over the workers' hours. It included polling data that showed 40% of BAME workers on insecure contracts said they faced the threat of losing their shifts if they turned down work, compared with 25% of insecure white workers. In relation to age, younger workers are also disproportionately impacted by the negative outcomes of zero-hour contracts. Recent research states that zero-hour contracts have a disproportionate impact on younger workers from poorer socio-economic backgrounds, as this group is twice as likely to be on zero-hour contracts. The research raised concerns that data in jobs with no training, decent pay and limited prospects may lead to apathy, resignation and anxiety amongst young people. In addition, the risk of limited financial independence for young people and their dependency on social welfare could result in further socio-economic exclusion. In addition to gender, race and age, it is important to note that there have also been concerns raised about zero-hour contract use for those with disabilities and migrant workers, which may also require further exploration. In conclusion, by reducing zero-hour contract use and providing secure employment conditions for women, those from BAME backgrounds, younger workers and others, that could eradicate a number of the detrimental impacts to their working lives, thereby meeting Section 75 requirements. That concludes the presentation, Chair. We're happy to take any questions. Thank you.
Thank you both for that overview. Really helpful to us. We've had a response from the department on some of the points that have been highlighted for scrutiny by yourselves. We just received that this week as well. So obviously we can look to see if there's any additional points that we need to get additional responses from the department on. A lot of the points we have had discussed with us by the various groups that have come to talk to us about the 0 hours bill and for example, some of the loopholes around clause 14 and things like that are mentioned in the paper that we've already we've raised with the bill sponsor, and she is willing to look at that. Obviously, we're in a position now where this isn't going to conclude before the end of this mandate. So there is, I guess, an opportunity to look at the further scrutiny points and to consider that for any potential legislation that would then be coming forward in the next mandate. And I'm sure the bill sponsor would be intending to look at this again in the next mandate. And the department has says that obviously it's a new decade, new approach commitment, so needs to be considered in terms of the department's forward work plan around employment law as well. So look, it's been helpful in terms of setting out all of the points. I don't have any specific questions. I'm not sure, Peter, if anybody else is indicating to come in.
Mr. Weir.
Well, you're sending me messages. Okay, Peter, do you want to come in then?
Yes, thank you, Chair, for that, and thank you for the presentation. Just a couple of queries I just want to check out, and maybe you've covered these. I know when you were looking at other jurisdictions, there's some have looked towards the idea of banding, and some have looked towards other measures in relation to it. I just wonder, one of the issues which I suppose we want to try and make sure that when we reach the point where the legislation, because this legislation itself won't hit the statute books this term, but may well be the foundation for what is there in a future term. But the mechanism, obviously, that's been used in the bill of sort of a threshold or trigger point at which then you can move from the 0 hours to a sort of banded contracts and that, but has a similar approach in terms of the sort of period of time of trigger point. Has that been something which is done relatively similarly in other jurisdictions, or is it a bit of variation in that? That's the first point just I wanted to raise.
Yeah, well, the best example of that would be from the Republic of Ireland and the I think it's the Employment Miscellaneous Act from 2018, which included provision around. So it's basically the reference period that you're speaking of, Mr. Weir, and in that legislation they used 12 months, not three. I think if I remember rightly, the 3 month period was suggested by the bill sponsor due to responses to her consultation. I think the 3 months came up because it allowed was advantageous to workers really, rather than wait for the 12-month period, which some people might think may be more balanced in terms of the employer as well, having an input into that. So basically, that's the only jurisdiction really that has a system of banded hours contracts in place. There are moves at the moment. There's a private members bill from a Scottish National Party member that's been introduced. It's really to ban 0 hours contracts. It's not to introduce a system of banded hours. But it is quite interesting at certain points of it in terms of what happens if the worker turns up and then there's no work available for them. In the bill, the provision is for 3 hours pay if that happens. But in the Scottish National Party members' private members' bill, it's the hourly pay will be doubled, if you like. So if you're asked to come in for 3 hours, you'll get paid for 6. And also travel expenses are taken into consideration, and childcare and things like that. So, but in answer to your question, Mr. Weir, 12 months is the reference period in the Republic.
Okay, the second point just I want to raise, obviously there's been, which I think, and I suppose I'm just trying to make sure that we're not priding ourselves on something which maybe may have a wider problem, a different sphere. So I'm going to ask a question which it may be difficult to provide an assessment of or provide statistics on, but obviously there's been reference that you've made and others have made that the prevalence of 0 hours contracts in Northern Ireland will be a lot less than corresponding jurisdictions, that we've got a much smaller percentage, and that might be sort of an implication of the structural breakdown of the economy here, or could be for a whole range of reasons. But I suppose there would also be a concern that, call it below 0 hours contract, there would also be a part of the economy that I'm not sure what the correct terminology would be. I think it probably would maybe used to be called maybe the black economy, but maybe that may not be the correct terminology anymore in that regard, of where you get employers, for instance, and I'm not talking about particular criminal activity in terms of serious crime or whatever, but for instance would be essentially employing people casually to the extent of cash in hand not appearing on the books or whatever, which is obviously, call it sort of even a layer that lies below that of 0 hours contract. I just wonder, is there any level of assessment what sort of what percentage of the economic activity in Northern Ireland does that fall into compared to other jurisdictions? I suppose one thing I'd just be slightly nervous of is in taking good action to try and sort of close loopholes in 0 hours contract, that we don't give an opportunity, or at least what's actually seen that employers almost go one of two directions and either push people in the sort of virtuous route, which is sort of more towards banded hours, but some employers who are more unscrupulous take a view of, well, actually, I'm not going to get caught up in this issue in the first place, so now I'm just going to get X, Y, and Z and just give them cash in hand. They won't appear anywhere in books and won't have a contract at all, type of thing. So I don't know, has there been any level of assessment of in terms of the prevalence of the problem here on that sort of, on effectively people working outside of the books here compared to other jurisdictions, or is that something because its nature is very, very difficult to sort of quantify or assess?
Well, I think you make a very, very interesting point to do with the collection of official statistics. And I made a point in section 1 about that there is and has been a large underestimation of the amount of 0 hours contracts in the UK labour market. And I think largely the problem with that is the question that the Labour Force Survey asks is basically about what types of hours that the worker is employed under, and so then they have a list of options to tick. One of which will be a 0 hours contract. Another one will be called in for work. So, or words to that effect. I can't quite remember the exact terminology, but so the respondent to the survey will tick as many boxes as they feel relevant. And so some people may not even be aware that what a 0 hours contract is, or if they are on a 0 hours contract, I may tick that called in for work box or other boxes like that. So there is a problem with estimating effectively the prevalence of 0 hours contracts in the economy. And that's something that I think the ONS are certainly working on. But in terms of that sort of black market economy, that kind of casual pay, I'm not sure. That goes beyond the scope of this particular paper, but that is certainly something that we could look at in future. I think that will be a valuable contribution to a future paper.
No, look, I appreciate it was probably a little bit unfair to throw it your direction on it, but I just wondered if you happen to have any information on that, because just as I said, just have a slight concern that you can see potentially certain employers who the danger, I suppose, the benefit of this is, as I said, that we get a much more formalised and better employment conditions and more certainty for people, as I think highlighted in terms of some of the particularly differential impact, but also then that we don't create situations in which it creates temptations for unscrupulous employers to go down a route which makes it even more casual in its nature in that regard. But that's more of a comment than a question, Chair. So thank you.
Thanks, Peter. I don't have anybody else indicating, Peter, do you?
No, Chair, there's nobody indicating here.
Okay. Well, look, thank you for the presentation. As I say, it's really helpful to us in terms of the scrutiny of the report that we'll be doing. So obviously we'll obviously be coming back to this one at some point. So thanks very much for your time.
Thank you.
Cheers. Okay, Peter, so moving on then to our next briefing.
Chair, it might just be worth, I'm very conscious of the fact plenary has started and we may have pressure on quorum. So, Chair, if the members are willing, if we went to items 7, 8 and 12 before the other briefing,
okay,
those are all statutory rules.
Okay, let me just get my Chair's brief in front of me again here. So item number 7 then is the SR 2022-72, the Public Interest Disclosure Prescribed Persons Amendment Order, Northern Ireland 2022. There's a clerk's memo at page 160 of our packs, and then the SR itself is at page 162. This statutory rule amends the Public Interest Disclosure Prescribed Persons Order NI 1999 by replacing the schedule to that order. It adds to the list of prescribed persons and amends the name and description of matters to the North Departments and the Secretary of State for Business, Innovation and Skills. Further, it removes the Treasury and Ofqual from the list of prescribed persons. Responsibility for the prescribed persons' functions of Ofqual in the North have been taken over by SIA. And finally, the order revokes the Public Interest Disclosure Prescribed Persons Amendment Order NI 2014, which is SR 2014 number 48. This statutory rule is subject to negative resolution procedure. The committee considered the SL1 at its meeting on the 23rd of February 2022, and there have been no changes to the policy content since then. So the rule will come into operation on the 23rd of March 2022. The Examiner of Statutory Rules has not yet reported on this rule, so members will be agreeing to the legislation subject to the Examiner of Statutory Rules report. So are members content that we put the question?
Thank you.
Yep. Okay, so the Committee for Economy has considered SR 2022-72, the Public Interest Disclosure Prescribed Persons Amendment Order, Northern Ireland 2022, and has no objection to the rule, subject to the Examiner of Statutory Rules report. So we'll move on then to item number 8, which is the SR, the Student Support, etc. Amendment Regulations. NI 2022. There is a clerk's memo at page 180. The SR itself is at page 182. The statutory rule makes provision for support for students taking designated higher education courses in respect of the academic year beginning on the 1st of September 2022. Specified changes will come into effect when the regulations come into operation. The statutory rule is also subject to negative resolution procedure. The committee considered the SL1 at its meeting on the 16th of February, and there have been no changes to the policy content since then. So the rule will come into operation on the 24th of March. And the Examiner of Statutory Rules again has not reported on this rule, so members will be agreeing to the legislation subject to the Examiner of Statutory Rules report. So Peter, just on this one, we when we considered this SR last year, we had raised some concerns around EU students and students going to study in the south and whether they are still entitled to tuition fee loans. So can we just clarify that? Can you clarify that for us now?
I can't off the top of my head, Chair. As you point out, we did get that all clarified last year, and we probably should have done a preemptory clarification of that this year. The rule doesn't come into operation until next week. Sorry, the week after.
Okay.
So we can ask for that information,
Okay.
and if you like, we can then bring this one back for the agenda next week.
Yeah, if members would be content to do that.
No worries,
And
sure, we'll seek
just that I think there's some changes around disability student support as well. So if we could maybe ask about that.
We will, Chair.
Okay, thank you. So which one are we moving on to now, Peter? Sorry.
Well, Chair.
Item number 12, which is the SL1 Employers Liability Compulsory Insurance Amendment Regulations, Northern Ireland 2022. There is a clerk's memo at page 39 of table papers. The SL1 itself is a page 40 of table papers. The main aims of the statutory rule are to update Schedule 2 of the 1999 regulations, which specifies those employers exempt from employers' liability insurance. The requirement for eligible businesses to obtain employers' liability compulsory insurance continues to be enforced by the Health and Safety Executive. The rule, excuse me, the rule is subject to negative resolution procedure, and the rule will come into operation on the 1st of April 2022. This is the committee's opportunity to consider the policy set out in the SL1, as it is not possible to amend once the rule has been made and laid in the Assembly Business Office. So are members content with the policy direction as outlined?
Thank you.
Okay, so we will go back then to item number 5.
Thank you, Chair.
Which is our briefing on the Onshore Fracking Prohibition Bill from RAISE. There is a RAISE briefing paper at page 14, and if we could welcome to the meeting Aidan Stennett, who is a research officer in RAISE, and I'll hand over to Aidan to make an opening statement, and then we can bring members in for questions.
Thank you, Chair. Can everybody hear me okay? Yeah,
Yes.
great. I have a quick presentation, so I'm just going to share my screen. Hopefully you can see that now. As you mentioned, Chair, I'm going to talk to the committee today about the Onshore Fracking Prohibition Bill, which is in front of the committee at the moment. I will cover some background, essentially setting out where the various jurisdictions in the UK and the Republic of Ireland are with regards to hydraulic fracturing at the minute. Then look at what the bill proposes in its one substantive clause, and then set out some considerations that the committee may wish to think about arising from that clause, and then look at some of the broader considerations that could possibly arise from the bill's desire to prohibit hydraulic fracturing in Northern Ireland. So, first of all, a quick tour of where hydraulic fracturing is in the UK and the Republic of Ireland. In Northern Ireland, there has been a presumption against planning permission for development seeking to exploit unconventional hydrocarbons since 2011. Interestingly, this is a presumption against the hydrocarbon exploitation in general rather than the specific hydraulic fracturing in particular. In England, following studies by the UK Oil and Gas Authority on the risk of seismic activity from hydraulic fracturing, the UK government decided not to no longer support the activity, and this has been the case since 2019. Prior to that, there were protections in place in England and Wales that prevented the activity in certain areas, such as areas of natural beauty, and also had a number of steps that had to be passed before the fracking activity could take place. In both Scotland and Wales, there are policy moratoria against the exploitation of unconventional oil and gas. In both jurisdictions, these are secured using the planning system, and they've come in quite recently in 2019 Scotland and 2018 in Wales. And the Republic of Ireland is unique amongst the 5 jurisdictions examined. It has legislation which was passed in 2017 and which made onshore fracking unlawful in that jurisdiction. And there are a number of similarities and differences between that legislation and what's proposed in this bill, which I'll draw the committee's attention to over the next few slides. So what does the onshore fracking bill propose? Well, it proposes amending the Petroleum Act of 1964. That act provided the department with the power to search for, bore for and get petroleum in Northern Ireland's strata, and that includes both the onshore and also the internal waters that are adjacent to Northern Ireland. It also provides DFE with the power to grant licenses to do the same, that is, to search for, bore for and get petroleum in those areas. So the one substantive clause in the bill seeks to amend that act to make onshore hydraulic fracturing unlawful. It also will prevent the issue of new licenses in Northern Ireland and will ensure that any licenses previously issued under the 1964 Act, which give permission to frack, will no longer have effect to the extent that they give that permission. Within the bill, onshore is defined to include the strata beneath Northern Ireland, but not the foreshore, not the internal waters adjacent to Northern Ireland, nor the UK territorial sea adjacent to Northern Ireland, and I'll come back to this again. So a number of considerations arise from that clause. First of all, there are possible questions over the definition of hydraulic fracturing. These were raised during the second stage debate and concern two specific aspects. First of all, it was questioned whether the definition applies to petroleum only. So the bill refers to fracking in a restricted context. If enacted, the bill will ensure that the department has no right to search and bore for and get petroleum by way of onshore hydraulic fracturing. Additionally, it would ensure that the department will be unable to grant licenses to do that under the Petroleum Act 1964. So it seems very explicit in its relationship to petroleum, and it doesn't, indeed the bill doesn't mention fracking in any other context. The second question raised is whether the bill refers to both low and high volume fracturing. So the difference between these two is really, well, it's set out in various literature, including academic and regulatory literature. So essentially, the volume referred to here is the volume of fracking fluid or water that's used in the process. Low volume fracking is generally used in the exploration of conventional oil and gas, whereas high volume is generally associated with the unconventional oil and gas, such as shale gas exploration. So the bill's definition of fracking is as follows. It is defined as the generation of mechanical fractures in the shale or strata encased in shale by means of the physical process of pumping fluid at high pressure, which is carried out in connection with the use of a well to search or bore for petroleum. So that doesn't mention the volume of fluid used. The Westminster Infrastructure Act 2015 does define fracturing, hydraulic fracturing, with reference to the volume of water used. And there's two measures here. It's either 1,000 cubic meters in any specific stage of the fracturing process, or 10,000 cubic meters in total. That definition only applies to England and Wales, and it was criticised at the time that act was passed, as the volumes chosen were found to have only captured around 43% of all the wells that had been fractured in the USA at that time. So the second area of consideration is the geographic extent of the proposed prohibition. So as I mentioned on the previous slide, the 1964 Petroleum Act vests the rights of petroleum found in Northern Ireland to the department, and that includes petroleum found onshore, but also in Northern Ireland's internal waters, or the internal waters adjacent to Northern Ireland. The prohibition is limited to offshore only, or the proposed prohibition, that is. So the proposed prohibition will not include the internal waters adjacent to Northern Ireland, even though those rights are vested in the department. That's not the case with the legislation introduced in the Republic of Ireland, which does extend to those adjacent internal waters. So this and the definition of fracking, as I previously spoke about, are sort of things that the committee may wish to tease out with the department, the bill sponsor, and other stakeholders to see whether the definition and the extent are appropriate for the purposes of the bill. And the final area that the committee may wish to consider arising from the bill are the consequences for breaching the proposed prohibition. So the bill makes hydraulic fracturing unlawful onshore in Northern Ireland, but it doesn't set out any penalties for breaching that prohibition. The 2017 Act in the Republic of Ireland does include such penalties, so any individual found breaking the prohibition can be fined or even imprisoned. And fines were also identified. This research also identified fines being used at state level in the USA and Australia. So moving on to some general considerations, just to preface this, that this report or this research paper has been prepared in the absence of the Hatch report, which was commissioned by the department to investigate the economic, social and environmental impacts of developing petroleum in Northern Ireland and also on conventional oil and gas in Northern Ireland. This has not yet been published, but the Minister did state at second stage that his intention to publish the report. The Minister also mentioned that the report had found only minor positive impacts from such development in Northern Ireland, and that the preferred option was to support a moratorium or ban. So in the absence of that report, the research that you have today draws off a number of other papers and studies just to look at the sort of general consequences of prohibiting hydraulic fracturing in Northern Ireland. So the first area where there may be potential consequences are on the public purse. The DFE and their guidance on petroleum licences do mention three sort of revenue sources for the public purse, including corporation tax, a supplementary charge, and royalties. Research commissioned by the Scottish Government noted that pursuing unconventional oil and gas in that region over 45 years could lead to approximately 1,400 million in additional tax revenue over that 45-year period, working out about roughly £31 million per year. On the flip side, a National Audit Office examination in England found that between 2011 and 2020, around 32.7 million had been spent on shale gas exploration by the public purse over that period. These were only the known costs, however, and that includes expenditure by the Department for Business, Energy and Industrial Strategy, but also things like expenditure by police forces, policing protests at proposed fracturing sites. Important to note here that that expenditure in England occurred despite there being no commercial exploitation of shale gas in the region during that period. There are also potential economic implications. So studies in Scotland and Wales found that pursuing unconventional oil and gas in those regions would have both positive GVA impacts and job creation impacts. So for example, in Scotland, the central estimate found that GVA would increase by an average of 27 million per year over the 45 years they examined. In Wales, they looked at a period of 2015 to 2019 and estimated GVA impacts of about 1.4 million to 3.1 million per year over that period. The difference here in the magnitude of impact was really down to the estimated resource that the studies were underpinned on or assumed for the study. It's also important to note that both these economic benefits and the fiscal benefits didn't measure against the counterfactual. So they didn't examine what the impact of alternative strategies might be on jobs, GVA, and the public purse, in order to include the costs associated with the potentially negative impacts of pursuing unconventional oil and gas, such as the environmental damage or potential health impacts. Additionally, it's worth pointing out that despite the identified benefits in Scotland and Wales, neither jurisdiction has pursued unconventional oil and gas exploration to date. I mentioned the social, environmental and health considerations. These are outlined in greater detail on page 109 of your packs, but just to mention that the academic and other literature does find both potential benefits and harms of pursuing unconventional oil and gas development, including environmental, social and health related benefits and harms. So these include things like emissions, possible seismic activity, possible water pollution and potential health impacts on those living close to wells. It's interesting that the literature shows that the emissions impact is really dependent on what you're measuring it against. So the emissions associated with unconventional oil and gas were found to be less compared to coal exploration, but higher compared to conventional oil and gas. And then finally, there are considerations around the security of gas supply. So there have been recent calls on the UK government to reassess its position on hydraulic fracturing and shale gas in England. These calls cite, amongst other things, energy security and the need to increase the supply of gas within the region. And the calls have been made against a background of unstable global energy markets and diminish domestic conventional natural gas supplies in the UK. It's interesting to note that despite that context and those calls, the UK government has to date in opposition changed its position on unconventional oil and gas or hydraulic fracturing in England. So that's the end of the presentation, Chair. And I'm happy to take any questions that you might have.
Aidan, thank you very much for that. Again, it's a really good overview of the various issues in relation to the BORs bill. We will be scrutinising this to the point of taking decisions around the various clauses, but the background information is in terms of the things that some of the stuff around the definitions and what would you call it, the application of the bill are things that have been raised with us already as well. And I think that, again, Peter, going forward, these are things that, you know, we can flag in terms of our report that will need to be considered in terms of a future bill. Obviously, as Aidan has pointed out, we were expecting the Hatch report to be published, and perhaps if we could ask the department around a timeline for that, because obviously the Minister did indicate that it would be published when he was setting out the intent around his preference in terms of the future petroleum licensing policy. And I think there is an expectation there that that would happen. So I don't have any specific questions. I'm not sure, Peter, if anybody in the room is indicating.
Yeah. Mr. O'Dowd, Chair.
Thank you
Go
for
ahead,
the
John.
presentation. And, it was very useful. Just to confirm again that the bill, in your opinion, simply refers to the extraction of petroleum and gases, and it's nothing to do with the extraction of water?
Well, based on the definition set out in the bill, that seems to be the case. It's quite specifically, explicitly referring to petroleum. It states, I'm sorry, I'm just trying to find it. It states that hydraulic fracturing in the context of the bill is the generation of mechanical fractures in the shale or strata encased in shale by means of the physical process of pumping fluid at high pressure, which is carried out in connection with the use of a well to search or bore for petroleum. And it doesn't mention hydraulic fracturing in any other context. However, I'll caveat that with saying that I'm not a lawyer, and you may, if you've concerns, it may be good to get some legal advice on the implications of that definition.
It's a good lawyer's answers, but that's great, thank you.
No worries.
We've no other questions, Chair.
No other people indicating. Okay, well, look, Aidan, thank you very much for the presentation. As I said, really informative as always.
Thank you, Chair.
So, Peter, we are going to do matters arising and correspondence by correspondence, if members are content with that.
Yep.
Just to check, there's still no response in relation to travel agents?
We've nothing.
Sorry if I'm pushing my luck here.
No,
and did the committee write in relation to hairdressers and beauticians previously?
yes, and we have a response to forward to them, so that's in matters arising.
Yeah. Okay.
But we still haven't had a specific. We have a number of queries into the department around the travel agents, and we haven't had responses. So we will continue to press for that. But if members are agreed then to dispose of items 6 and 8 via correspondence, I'm getting agreement,
Yeah,
Chair.
Peter, and I suppose just in relation to the point that John has raised, the response from the Minister to the hair and beauty sector, it's a bit disappointing, and I'm sure it will be disappointing for those that have received it. And I think it would be just worth us emphasising to the Minister and the Department that both those and the travel sector have been badly impacted, and any support that could be provided, action really should be taken around that.
Chair, we will do that.
But if members are content that we will deal with, I think it's item 6 and 9, isn't it, Peter, on
Yes,
the agenda?
Chair.
Yeah.
Yes.
Okay, so we'll then move to item number 10, which is any other business, and none has been indicated.
No one is
And-
indicated in the room, Chair.
Thank you. And then we'll move on to item number 11, which is the date, time and place of our next meeting, which is Wednesday, the 16th of March in the Senate chamber at 10 a.m. And just to remind members also that we have the informal meeting with Sir Michael Lyons on the Invest NI review tomorrow at 1:30, and members have already been sent a link to that meeting. So thank you.
Thank you, Chair. Thank you, members.
This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room 30.